It's great to be here today. And we have a range of perspectives as well as a range of experts here, which is great. And we'll keep it pretty fast-paced. We've got a large panel, which is also good. And we'll start with everyone just giving a few minutes of their own takeaways and their legal bottom line, we'll call it, with respect to the oral argument. But first, let me ask how many people in the audience were actually there at the oral argument. Okay, quite a few were listening to it. Good. Okay, so you've got an educated crowd here, which is good. And let's start on this end. Markham?
Thanks, Michele. From my perspective, the case in large part turns on the Brand X precedent. The court in Brand X found that the act was ambiguous about whether cable companies offer telecommunications with cable modem service. The question was whether the transmission component of cable modem service was sufficiently integrated with the finished service to make it reasonable to describe the two as a single integrated offering. Okay, I'm sorry. The question the court said then turns not on the language of the act, since the court determined it was ambiguous, but on the factual particulars of how internet technology works and how it is provided, questions that Chevron leave to the commission to resolve. And here the commission is on its strongest legal footing before an appeals court, where they will get the benefit of the doubt as long as they have a reasoned fact-finding and policy decision-making process. And the petitioners here do not challenge the finding that the biased providers, the broadband internet service providers, have both the incentive and ability to take actions that could threaten the internet, nor that the rules are tailored to prohibit such actions. Nor do the petitioners challenge the FCC's authority under Section 706 to promulgate rules governing broadband internet service providers. So on this question of the FCC's fact-finding, I think the FCC has a strong argument. I think they are solidly within the Brand X precedent, and I think it was a strong posture to bring before the court.
Excellent.
So what I guess I would add to that is that Judge Williams was new to this panel and has sort of a deep knowledge of general common carrier regulation. And he sort of brought an interesting perspective to this by focusing on paid prioritization, and specifically whether, that in general that's been acceptable under common carrier regulation, and whether in the record in this case, the FCC had pointed to a real showing of harm from paid prioritization. Now, this is actually something the Verizon court did address in the sense that, they determined that the FCC had sort of reasonably found that there was a threat of this, and that broadband providers had the capability to, in fact, engage in paid prioritization. But I think Judge Williams approached it slightly differently and really focused on whether there was a demonstrated harm to actual internet traffic from this. I think since he's now a member of the panel, the court will have to the other judges will have to grapple with some of his questions. And I think at one point Judge Tatel also sort of hinted that this was sort of a new issue by really probing the FCC on whether or not the FCC's rationale for switching from 706 to Title II, and really asking the FCC to clearly articulate the rationale for taking this new sort of sweeping approach. So I think that I certainly agree with what was just said, but I think that the judges were interested in the FCC's sort of new sweeping approach under Title II, potentially having to have a stronger sort of rationale for sort of demonstrated in the record.
Well, given that I was wireless bureau chief, I guess I'll do a little bit about the wireless argument. But before I get there, the very fact that there were a lot of questions and that there was a separate argument about the wireless issue points out something that's going on here that's a little different than Brand X, which is when the FCC decided to reclassify under Title II, one of the things that they said was this will give us a stronger legal foundation. And I think, well, in my public comments, I disagreed with that. I think the argument indicated one of the issues with that, which is whatever Brand X says or doesn't say about these issues, by reclassifying under Title II, the FCC also brought in a host of new issues that weren't in Brand X, and the wireless provision in Section 332 of the Act is one of those. Because when you're under Section 706 and whether you direct authority now or ancillary authority, that authority was arguably separate from Section 332. Well, what's Section 332? There's a provision in there that's separate and apart from the definitional sections of the Act in Title I that talk about telecommunication service and information service and telecommunications. That says there are private mobile services and commercial mobile services, and private mobile services cannot be regulated as common carriers. So this is a new issue that, insofar as it's not addressed in Brand X, that the court has to tackle in this case, given the way the FCC went. There are a number of issues here that the court addressed. I mean, basically three issues that they seem to ask questions about. Definitionally, one of them is in order to be a commercial mobile service, it has to be interconnected with the public switch network. Folks like myself would argue that's always meant the public switch telephone network, but counsel on the other side who probably will have things to say about this is, well, it doesn't say telephone. So does the FCC have discretion there to expand it? There's also a functional equivalence test in the Act. In other words, something can be a commercial mobile service if it's functionally equivalent to a commercial mobile service. I thought it interesting. Judge Srinivasan said, if we get to that argument, I don't know what it adds, because haven't we already assumed that you've got a commercial mobile service, or that you don't have to have telephone in the Act. I'm sorry. Yeah. So, but the one I think both Judges Tatel and Srinivasan focused on, the issue that could be pivotal, maybe. I hesitate to predict, but I think both by two judges asking questions about it, they're concerned about it, and that is there's another argument that this definition says the public switch network, and the a traditional cell phone that relies on the North American numbering plan can't connect with somebody who's using an IP address. Now the FCC said, well, both telephone numbers and IP addresses are part of this same public switch network, and the question is that a reasonable interpretation of a statute which, at least arguably, and certainly that's the argument of appellants, talks about one network. The other aspect of that is the FCC itself in the order said, one of their justifications for regulating broadband was, well, it's ubiquitous and you can reach everyone on the internet. But so that's the question. Well, wait a second. You say on the one hand we're regulating this because you can reach everyone on the internet, but on the other hand, you're combining two networks that don't allow people to communicate with one another. I don't know where the court's going to go on that, but the fact that two judges asked questions indicates there's some interest there, and could be a difficult decision for them.
Great. Pantelis?
Thank you, Michele. Good morning. First of all, let me say that I agree with everything that my partner Markham said. Markham has nurtured net neutrality from the cradle, and I think I'm confident he will see to it that it has a successful and prosperous adult life as well. My view of this oral argument and the aftermath of commentary that we have seen it reminds me of something that a court said about legislative history, that it's like a cocktail party where each one of us looks over the heads of the other guests to find their friends, or at least the people we know. And so there was an interesting piece in Communications Daily yesterday that was, I think, an illustration of that, various commentators, many of them esteemed, many of them are colleagues on the bar, said things such as, it's an all but foregone conclusion that the court will rule one or the other way. Wells Fargo analysts were cited as saying that, in their view, the oral argument was a positive for cable, meaning presumably that they were intending their clients and investors to invest accordingly. And what accordingly means is unclear in light of the fact that the record shows that the open internet rules have had no adverse effect on investment or stock prices. There was also some attempt to move the goalposts. There was one commentator, and I think a party to the case, who said words to the effect that, the FCC needs to win it all, otherwise it loses. And I don't think that's accurate. I think both parties face risk here. I think there are some issues that are more important than other issues. And of course, classification, as Markham alluded to, of broadband access under the definitional section of the Act is the all-important predicate to everything. I think it must rank as the most important issue. And of course, it's better to win on the important issues than on the less important issues. I do think that it's possible to observe the oral argument and say that the judges were skeptical about certain arguments of the petitioners and about certain arguments of the FCC and of ourselves, of intervenors. But I think it would be dangerous and somewhat simplistic to jump from that into some sort of a prediction that there will be a Solomonic baby splitting in the decision. I think the court will look for a viable decision. I don't know what it will be, and I think it will probably surprise us all.
Sure. I don't disagree that it's hard to predict. I will say that. I think that we saw over the few hours in the courtroom, we saw some very difficult questions posed to both sides on really all of the issues. One issue that hasn't been spoken about yet that I worked on in this round and of the litigation and last time around is the First Amendment. And I think that the First Amendment should actually move the goalpost on the question of whether the FCC receives deference as to its classification decision and really the whole case, because when you have a constitutional question involved, generally speaking, the agency is not given deference on its determinations. I think that at least two of the judges, Judge Williams and Judge Srinivasan, were very concerned about the FCC's blanket assertion that broadband providers exercise no First Amendment protected editorial discretion at all. There were a lot of questions asked of the FCC's counsel concerning that, and I think that that's a very important question that the court's going to have to grapple with if it decides that the classification decision was a reasonable one under the statute. I also would like to point out that there was a challenge to the FCC's authority to rely on Section 706 for the rules. The main petitioners didn't challenge that, but Alamo Broadband and Dan Berninger have challenged Section 706 as a basis for the rules. So we do still have the question live in the DC Circuit as to whether 706, standing by itself, separate and apart from Title II, can authorize the rules. So I think, like Pantelis said, it's anyone's guess as to what will happen, and I do think that the court will surprise us all, but they certainly have a lot of hard issues to deal with here.
Well, to start, Eve is quite right that the 706 question is a live one. I think it wasn't actually resolved by the Verizon decision. If you read that decision, it's pretty clear that the court's discussion of 706 was dicta. It was not binding upon future courts. It wasn't necessary to resolve the case. And that same issue is right now before the Sixth Circuit, and it's very likely that that decision could come out probably later than this one, but it could be the case that you see both issues going up to the Supreme Court simultaneously. Anyway, let me say what I think this case is about. I think it's not about net neutrality. I think that's a red herring. It's about the FCC's claims of sweeping authority by reinterpreting the Act, and reinterpreting it not just in terms of reclassification, not just reinterpreting the term telecommunications, but reinterpreting what it means to be interconnected with the public switch network and what that network is. And by doing that, the FCC has opened the door to all kinds of problems, and I think really opened the Pandora's box, not just of internet regulation under Title II, but with other implications, like most notably the Community Assistance to Law Enforcement Act uses the same term, telecommunications service. The FCC gets to decide what a telecommunications service is. And if you are a telecommunications service, your service has to be wiretap ready, which means that you have to be able to turn over the contents of your communications to law enforcement, which sounds a lot like what the FBI has been asking for recently. So that's just to illustrate why we're suing, why our group of internet freedom intervenors who are Silicon Valley entrepreneurs and investors are so concerned about the order's implications, not about net neutrality as such, but about the FCC's claims of authority. And I think it's very likely that we're not going to get a clear answer from the court here. I think everyone who said that today is right. I think there's a common misperception when people think about oral arguments, especially at the appellate level, that it's like going to an oracle, and you ask the oracle a question, and the answer is hard to understand, and you may not understand the answer initially, but you at least get a question and an answer. That's not how this works at all. I think a better analogy would be something like that there are dozens or even hundreds of little questions along the way. If you think about the chain of logic, write them down on each of them on a sheet of paper, little piece of paper, and then throw them up in the air. The court's first job isn't to answer the questions, it's to put all the questions back together and arrange them in the right order. And it's often the case in arguments that those questions end up getting put in the wrong order, or some of them end up getting lost completely. And so you get decisions that miss crucial premises, that don't address things that the Supreme Court might later review and decide had been missed. And I think that's likely what's going to happen here, because the oral arguments really, except for a single question from Judge Williams, did not touch upon the focus of our brief and the focus of the amicus brief filed by the International Center for Law and Economics, which is the question, the basic question of whether Chevron even applies. So when you hear everyone talk today about Brand X, what they're really talking about is the idea that the FCC should get deference in interpreting ambiguous provisions of the statute. And our brief explains why we don't think the FCC ought to get that deference. And I will acknowledge that this is an issue that is very much in flux, and it's the sort of thing that is more likely to be resolved by the Supreme Court than by the DC Circuit. But very briefly, and we can talk about this later, very briefly I'll just lay out the three reasons why we think deference does not apply here under Chevron. Number one, we think this is the fundamental major question. Indeed, it would be hard to imagine a more major question, which is a doctrine that the Supreme Court began recognizing back in the 1990s, into which the the court has breathed new life in the last few years, most notably in the King versus Burwell decision. The Verizon case briefly considered this question and moved on past it pretty quickly. But I think, number one, the FCC has gone radically further than it did last time. This is far more a major question than the very limited question of the rules at stake last time was. And number two, the court really has moved a lot further in, most notably, King versus Burwell. Second, the Supreme Court also decided a major decision in the Utility Air Regulatory Group versus the EPA, where the agency had said that they needed to radically tailor the Clean Air Act in order to make sure that when they regulated carbon emissions, they didn't regulate every home and car in America, they only regulated major emitters. Well, that's not what the statute says, and if you apply the statute, you would actually wind up with an absurd result, which the agency essentially acknowledged by virtue of saying it needed to tailor its rules so dramatically. Well, that's precisely what the FCC has done here. They use the word tailoring dozens of times. And they don't seem to have any defense for this. They don't acknowledge or discuss UARG at all, despite the fact that they really should have read the case and thought about it, and maybe been a little careful about using the word tailoring. They simply say in their brief something along the lines of, well, we get broad discretion to forbear, which maybe the EPA didn't have. To us, that totally misses the point, because forbearance, yes, the FCC does get broad authority and broad discretion, and that's precisely why forbearance can't fix this problem, because forbearance is a temporary decision. It can be reversed later. There's no way for the FCC to permanently change the act. That's not what Congress intended for the FCC to do. And so the fact that the FCC feels it needs to forbear so broadly from so many provisions of Title II to us will be interpreted, at least by the Supreme Court, if not by the D.C. Circuit, to be evidence of the disconnect between what Congress intended and the results that the agency itself acknowledges. And the third case is a line of cases that go back to the 80s, the benzene case, which very briefly say that when the court examines issues where the agency is making major decisions, it's going to be required to make some assessment of costs and benefits in a more rigorous way than it's done here. And so for all of those three reasons, I don't think Chevron even applies. And whatever decision you get here from the D.C. Circuit, I think will be fundamentally questioned by the court, which is moving in all three of the directions I alluded to.
Well, that was a range of policy and legal issues, and I'd like to ask Markham to respond on a couple fronts, but you can take this in either order, but one is on the policy points that we heard, but the other is on the legal points with respect to deference and the amount of deference that the court could or should defer to the FCC here. There was a lot of discussion during the 3-hour oral argument about this Brand X case and what that means with respect to deference and reclassification, and whether or not the FCC not only did fact-finding, but if it really made sure there was an adequate reason and rationale backing up its decision in that regard.
Thanks, Michele. So first I would say that what the FCC is doing here and has done here is not all that unusual or unprecedented in the arc of regulation in this space, and indeed in its regulation over the distinction between enhanced services and basic services, which was the predicate distinction that the FCC used that was incorporated into the 1996 Act. Basic services essentially being the transmission platform for telecommunication service, enhanced services, those things that were riding over the top of those things like email and other things that could be separated out from that. So the FCC has a long history of regulating services and looking at the distinction between basic services and enhanced services. And indeed, in the 80s, they sometimes classified certain things as enhanced, as basic services that they later then determined were enhanced services. They switched their position after going through fact-finding. And so indeed, these distinctions have not been set in stone historically. And so when the FCC determined in the 90s that these services were integrated, that cable modem service was integrated and was an information service, that was a fact finding that they certainly could revisit, and they did, and determined that no, there is two separate services, an information services and a telecommunication service, and that after engaging in fact finding determined that the broadband internet access service was indeed a telecommunication service. So I don't think it's all of that, it's not that unusual within the arc of the regulatory space here. And against that, let's not forget that the FCC, even when it made these classifications in the early 90s, which the Supreme Court affirmed, always said that even though they were classifying cable modem services as information services and not telecommunication services, that the FCC would be able to protect consumers from the providers of these information services if they were consumer harms. It resulted in the Internet Freedom Doctrine that Chairman Powell promoted and that Chairman Martin attempted to enforce in the Comcast decision largely. And the Supreme Court, indeed, in affirming the FCC's fact-finding in Brand X, noted that the FCC had authority under theories of ancillary authority to protect consumers in the space and to regulate these providers in the space. So I don't think it's all that unusual to say the FCC is regulating broadband internet access service providers. They have a different theory after a fact-finding than they did a decade ago, but it's not unusual or even surprising to note that the FCC would be regulating them. Indeed, on a bipartisan basis, every chairman of the FCC has said that they need to regulate broadband internet access service providers to look for consumer harm. They may have a different scale and scope of those regulations, but it's not surprising. And against that, let us keep in mind that no one challenged really the fact-finding, which the Verizon court affirmed, that the internet, as successful as it has been, as really the most successful communications platform in history, that its continued success is not inevitable. And indeed, the FCC found that the internet was at risk from abuse by broadband internet access service providers that had the incentive and ability to engage in tactics that would harm the internet. That fact finding is not seriously questioned. So against the argument that the FCC is regulating something that historically has never been regulated, I would take issue with that. Indeed, that instead of harming the growth of the internet, it's not seriously questioned that the FCC has taken action to protect the growth of the internet.
Any other commentary about the FCC's authority to act with respect to Chevron deference and whether or not the court applied that correctly and that that's the right standard here? Any other thoughts from others?
I came here full of good intentions and a desire to maximize the areas of agreement with my co-panelists, but I couldn't help observing that Berin's positions reflected a worldview somewhat different from mine, and in fact different in so many particulars that it's difficult to know precisely where to start. But let me start from your question, Michele, and talk about deference. Berin mentioned the King v. Burwell case, which is the Supreme Court healthcare case. That case stands for the proposition that the IRS, which has a lot of expertise on tax matters, has no expertise whatsoever on healthcare regulation. It would be relevant here only if the Customs Service had promulgated open internet rules. It's not applicable to this case because it is the FCC, the Expert Telecommunications Agency, that has done so. And if I may, Michele, I could perhaps try to dispatch a couple of other points that
Absolutely.
That Berin made. Berin started by saying that this is a broader fight. This is not about net neutrality. It's about a massive attempt of the FCC to reclassify. And I will point out that the petitioners themselves are of two minds on this. Some parts of the brief say that what the FCC did below was results-driven. In other words, that it wanted open internet rules, and to that end, it reclassified. Some other parts of the brief, and I was ready to cite to pages back on Friday, but I'm not ready to do so any longer, said the opposite. Said that the open internet rules were an excuse for the reclassification. And so this is an inconsistency simply because if you say that one thing is a means for another as a purpose, it's hard for you to credibly also say that the second thing is a means for the first thing as a purpose. And finally, Berin referred to the Verizon decisions holding that the FCC has authority to proceed with the Section 706 as dictum. It was not dictum. The court in Verizon had to decide whether the first open internet rules were valid. The necessary conduit to deciding that had to go through the question whether the agency has jurisdiction under Section 706. So it was a necessary predicate for the court's decision.
I'd like to respond to that, if I may. I think that reasonable lines can certainly differ on the 706 issue and how essential it was to the court's decision in Verizon, because the court actually struck down the rules in Verizon based on the fact that they were impermissible common carrier regulation. Common carrier regulation could only be imposed to the extent that the providers were providing a telecommunications service, and at that time the FCC had continued to classify broadband internet access service as an information service. So the Act itself would have prohibited the common carrier regulation from being imposed on the providers under the definition the FCC had applied. And so the discussion of 706, I think, is not at all essential to striking down the no blocking and no throttling rules, and the transparency rule, which the court upheld, section 706 wasn't even at issue. So I just respectfully disagree that issue cannot be raised again in this case. And I also think that, regardless of what the briefs of some petitioners might have said about the decision-making being results-oriented on one direction or another, I think that the FCC has been pretty clear in the past and was clear in response to a difficult question, I think, asked by Judge Tatel at the argument. He referred to the commentary by some people saying that he had given the FCC a roadmap to follow 706 through to adopt and justify open internet rules, and asked counsel for the FCC why they didn't follow that. And the answer, I can't quote it anymore, I could on Friday afternoon, but it definitely implied that the agency had looked at 706 and determined that it was not sufficient authority to adopt the rules that the FCC wanted to impose on broadband providers this go-round. So just 2 points to add to the debate.
And just to explain what Eve means, the reason 706 wasn't at issue is that, first of all, the FCC in the Open Internet Order in 2010 didn't actually rely on 706 for the transparency rule, which is the only thing that the Verizon court upheld. Moreover, Verizon was not actually challenging the transparency rule, which is uncontroversial. And then third, the court could have reached that decision based on simpler grounds, as Judge Silberman pointed out in his dissent. So again, those are all reasons why I think the 706 issue is a live one. Now, of course, the other side here might say that, well, we're being hypocritical because many of the broadband companies said to the FCC, just use 706, and that's a better option than Title II. Well, I don't think that was hypocritical for them. That is what the DC Circuit ruled, rightly or wrongly. I've always been consistent in saying that 706 can't possibly be reasonably interpreted as a grant of authority. But when I say that this case isn't about net neutrality, but about the FCC's power, what I really mean is this issue could have been resolved legislatively. We've had at least 2 congressional attempts, the first by Republicans back in 2006 when they passed a Communications Act update with a veto-proof majority in the House. It would have given the FCC authority to enforce the Open Internet Policy Statement. And then in 2010, when Democrats tried to reach a deal, we could have resolved that. We could resolve it now. And all that is standing between us today and getting a legislative solution to this issue that crafts narrow authority for the FCC without broad, open-ended grants of authority is the fact that the same angry mob that got the president involved here has made it politically impossible for Democrats to come to the table and reach a deal.
And I want to get back to that congressional element, because I think that's an important forward-looking piece of this grander puzzle. But in the meantime, one of the interesting elements, I thought, of Judge Tatel's remarks and questions at the panel was his focus on the consumers. And he really focused on not only what is an information service, but what services are the consumers being offered? And then he even took it further, what do consumers think they're being offered? Which was an interesting way of casting it. And it ties in a bit to the title of this program, which is, what will the case mean for consumers? Well, certainly Judge Tatel had that on his mind. And I'd like to get some perspectives from the panelists. Was that the right way for the judge to be focused here on the consumers themselves and what they thought they were being offered? And of course, he got pushback from the key petitioners who thought that, in fact, no, that's not what they're being offered. It's really X, and in very technical language, he said, but no, what do consumers think they are getting here? Anybody comment on that aspect?
Yeah, I'll give it a thought, because so I filed an amicus brief on the First Amendment issue, and some early reports were from the press were that it didn't get much play, and perhaps true, perhaps not, but I found the judge's questions about it very interesting. Especially a couple of the judges said, well, if it's common carrier service, then haven't we already decided that the First Amendment doesn't apply? And it's followed up by Judge Williams' questions about service Metro PCS offered, the name of which I can't remember, but at various times, you could, whether it's a music service or video service, T-Mobile's doing something similar now. They allow you to stream things wirelessly without accounting towards your usage limit and the like. Judge Williams' questions along those lines were, well, then it's not broadband internet access service. Why is that important? Well, and it's not just related to the First Amendment issue, but there's a tension here. On the one hand, most net neutrality advocates tend to decry those types of arrangements as violations of net neutrality, in spirit at least, if not rule. And the FCC itself, has evidenced a desire to try to force, if you will, broadband providers to provide an undifferentiated service. And I can't cite the paragraph, but in the open internet order, they say, well, we'll apply, very close scrutiny, keep a tight eye on whether or not broadband providers who claim they're providing a non, broadband internet access service are just trying to circumvent the rules. Well, one has to wonder if the judges resolved the First Amendment issue along the lines of, which their questions indicates a possibility. Look, if you're holding yourself out there, under kind of traditional notions of what it means to be a common carrier, as providing sort of undifferentiated connectivity to the internet, well, the First Amendment doesn't apply. But if you are telling consumers that's not what we're doing, it's a non-broadband internet access service, and why would that be relevant? Well, that would just, puts an end to the arguments that something like what T-Mobile is doing is a violation of net neutrality. And if the FCC then tried to say, well, we think you're just trying to circumvent the rules, depending on how it's written, the First Amendment could say no FCC on, an as-applied challenge. You don't have any say over this because now it is a First Amendment issue and you're done. I'm speculating quite a bit here, but I don't remember the question. But
I was asking about the judge's interest, especially Judge Tatel, in consumers, and not only what services are they getting, but how do they perceive those services? And is that, one of my thoughts is that a relevant question? Was he driving at something there appropriately or not? He had a goal in mind.
So I think I addressed it, right? I mean, what I was trying to say is whether, I'm not sure legally how important that question is per se under the statute, although judges' opinions are often informed by, broader policy concerns than black letter law. That's one aspect. And then I guess I was saying I actually think, given the questions, could be that how consumers view it becomes a very important question under the First Amendment. That's what I think.
Well, I think it's an encouraging set of questions because I think it demonstrates that we are indeed under the umbrella of the Brand X precedent. And one of the key findings in the Brand X case was asking what were cable companies offering? Were they offering telecommunications with cable modem service? And on this question of what the offer was, the Supreme Court gave deference to the FCC's determination to determine what consumers perceived as the offer. And here the FCC provided, after looking at the record, a determination that the consumers perceive the offering as a service that will allow them to get to all or substantially all endpoints on the internet, and that when they subscribe to broadband internet access service, they expect their broadband internet service to connect them without change or modification of the content to a website, and that their communications to that website will be transmitted without altercation. And it's the classic definition of a telecommunications service. So how the consumers perceive the offering was a key part of the FCC's factual determination, and of course it was a key reason why the Supreme Court in Brand X affirmed the FCC's factual determination when it made the cable modem order in the first place. The FCC simply re-looked at the fact-finding and came out with a different conclusion. So I find those line of questionings a valid vindication that we are indeed firmly within Miranda X precedent.
Great.
Yeah, it's also fraught with peril. I mean, the FCC has invented a new standard for deciding whether something is interconnected, which, by the way, it didn't come up with until the last minute because it changed its mind after doing all of that supposedly careful factual research that Markham keeps alluding to, which, by the way, we and others did challenge. And the FCC came up with, at the last minute, a standard. It comes up in a few places, legally speaking, but in one case it's about the offering, in another case it's about what it means for a service to be ubiquitous. But it sounds great. It sounds like, oh, the FCC is really focused on consumers and what they want. Well, among other things, what it does is open the door to further expansion of the definition of telecommunications service, because once it becomes about the perception of consumers and what consumers are using, it becomes a very easy matter for the FCC to start subjecting other services to Title II, which means to its discretion, to regulation under broad and open-ended standards, which is the real issue here. And I just want to respond very briefly to one thing that Markham said earlier. Markham said that, of course, the FCC had always claimed authority under other provisions, and the FCC in oral argument said that it was really important in the cable classification order that the FCC said it had other sources of authority. Well, it did, and it still does, and that's ancillary jurisdiction. And I actually don't have a problem with the FCC regulating necessarily. My problem is the means by which it does so. And the key difference here is under ancillary jurisdiction, the FCC has to actually make a showing that regulation is necessary. It's a much more difficult standard than simply claiming the moon, the sky, and the sun under Title II, and then deciding what to do with it, and going about forbearing or unforbearing and enforcing broad and open-ended rules.
Well, I just want to add one more. To be clear, I do think the judges were asking those questions because of the way the FCC decided to exert jurisdiction over interconnection, if you want to call it that, or as the judges said, the second half of the service, sort of from the ISP to the edge. So the FCC said they didn't classify it one way or the other, but they said we'll apply Section 201, maybe 202, I can't remember, but 201 to it because consumers' expectation is they're getting to connect to all points of the internet. And for that to be true, there have to be interconnection agreements in place. The judges, I think, were skeptical of the argument. It's hard to say how they'll rule, but I do think the question of how consumers perceive it is directly legally relevant to that question. I started with the First Amendment because, that's what I filed my brief on, but thought I'd round out the conversation there.
I'm glad you raised that because that was going to be my next question. On the issues of paid prioritization and IP interconnection in particular, all the judges seem to have a few more questions and were a little bit more concerned, and a lot of the analysts afterwards and the commentary afterwards was about, well, maybe that's on shakier ground. Would you agree or disagree based on the questions? And do you think the FCC does have an appropriate rationale for regulating those services the same way?
Well, since I already mentioned
Yes.
it, I'll just say on the interconnection point, I think a couple of the judges were skeptical about how it would work as a practical matter. And it's very analogous what happens in the interconnection agreement context to retransmission agreements and just video programming agreements on sort of traditional cable / in FCC techno jargon they call MVPDs, right? So the FCC's had this ongoing proceeding on agreements between broadcast television stations and MVPDs / cable companies. When they get into a dispute over what's going to be paid for programming, you end up with what's called blackouts, right? There are statutory provisions around this and rules about it, and I don't really care about the substance of those for the purpose of this discussion, but one of the issues that comes up is let's be clear, right now there is not a black letter no blocking rule. They are allowed to have blackouts while they are in a disagreement, right? One of the practical sort of policy reasons to allow that to happen is, well, yes, consumers go without a certain program for a bit of time, But on the other hand, it forces companies to come to the table and reach an agreement, at least theoretically. And what Judge Williams, in a couple questions asked about when I say, what's the practical impact of this, is he said, well, wait, I think the words he used were cast a shadow on the negotiations. What the FCC, while they disclaimed they were doing this as a matter of black letter law, since they didn't technically reclassify this side of the service, but I think what Judge Williams was asking isn't the practical effect of saying this back half of the service is automatically impliedly part of the consumer service? Isn't the practical matter that if you can't block content to consumers, that means there can't be sort of the internet version of blackouts? And I think he did at one point ask, so doesn't an ISP just have to carry it no matter what the interconnection party agrees to pay or not? And I think his questions are probably more directed at that, but I also think Judge Srinivasan also asked about the practical aspects of that particular issue. So the FCC kind of is having its cake and eating it too a little bit here with, well, because General Counsel Sal's response was, well, blocking is not per se prohibited. But then the judge is saying, well, isn't it impliedly prohibited, and then how does that affect the negotiation? I think there are some complex issues the judges were struggling with this interconnection question, and the FCC sort of punted on it in the order, and it'll be interesting to see how the judges react to that.
Pantelis?
Thank you. I don't want to make inferences from the back and forth of the questioning that occurred at oral argument, but I do have some views both on interconnection and on paid prioritization. To start with interconnection, I don't think there's much dispute that we're talking about the door to the ISP's pipe. And when somebody is a gatekeeper, the most likely place to ask visitors for a toll is that door. And so I think that's what the FCC recognized when it said that interconnection is part of broadband internet access service. And to tie that to the fact that internet service providers promise, indeed, that they will be able to get their users everywhere on the internet. Now, Fred has raised some points about that, and I think, Fred, you yourself have rightly admitted that they're somewhat speculative or academic, because when Comcast comes to me, Comcast says to me, pay $90 or $70 or whatever the price is, depending on the speed, and I will get you everywhere on the internet. Comcast has not yet come up with a service that says this is a service targeted at people who don't believe that Shakespeare was the author of Macbeth. And I will get you to only those websites. If that occurs, then the FCC can look at it and determine whether it qualifies as a broadband internet access service. So there is some degree of speculation in this set of points. Now, as for paid prioritization, what I would like to observe is that weighty petitioners, such as AT&T itself, are on the record below us saying that there probably should be a ban on paid prioritization. And to me, that appears important.
Eve?
I think that, to pick up on something Berin said before about a related issue, I think the idea that the FCC gets to decide where the line between a service that offers access to all or substantially all the internet and only part of the internet is fraught with peril from a First Amendment perspective, because it puts the FCC in the position of not just deciding whether or not a service is a broadband internet access service or not. It puts the FCC in the business of deciding whether or not a provider has First Amendment rights. And I think that that's something that we should be fearful of from a much broader perspective, because that's not, that's something that just doesn't, personally, it doesn't make me comfortable. And I think that it's a rather extreme position for the commission to take, and it's not just that. They said in the order that a family-friendly internet service would be subject to the rules and reviewed for reasonable network management. Well, so the FCC is deciding whether a curated service is not only subject to the rules, but whether the actual offering of that service is itself reasonable. And of course, there's no guidance whatsoever in the order as to what and how the FCC will interpret those terms, and they're broad on their face. So I think that that's something that the judges were focused on that in the argument in the First Amendment discussion, trying to understand whether the commission's position was really that no broadband internet access service provider could ever exercise editorial discretion. And so, I think that that's something that I hope they went home on Friday night and will be thinking hard about as they move forward.
Two points. So first, to what Eve said, this illustrates not just the Pandora's box, the policy implications of what the FCC is doing, but also the questions that the Supreme Court is going to be looking at. I mean, we have Supreme Court justices on both sides of the aisle, so to speak, who are very concerned about undermining First Amendment rights. And essentially what the agency seems to be arguing here is that an administrative decision determines what level of First Amendment protection you get. And just think about that for a second, right? That's a very chilling idea, literally, right? It would mean that you could bypass First Amendment jurisprudence by simply declaring that a new technology or platform doesn't get First Amendment protection. Now, that sounds an awful lot like, to me, like Hillary Clinton waving her hands today about, those First Amendment issues that might be raised, et cetera, about regulating encryption, right? Same thing Donald Trump says, right? That to me is deeply disturbing, and again illustrates why this is going to be a much harder case for the Supreme Court to resolve than the DC Circuit's decision might be. Second point, just briefly, just want to point out the irony here that Markham and Pantelis keep emphasizing that this essentially is about getting consumers what they've been promised, and it's about making sure that essentially that broadband companies are not deceiving their consumers by promising them one thing and giving them another. Well, gee, if only we had another agency that used to have jurisdiction that is able to go after deception, including cases of material omission, like the Federal Trade Commission, which is the agency that could have policed all of these issues and could have addressed the ultimate case here, the Comcast BitTorrent case, and would have done so had it not been for the insistence of the chairman of the FCC at the time that he was the decider and he was going to prosecute this case.
Let me move on to mobile broadband, because that was a very interesting part of the Supreme Court argument, the DC Circuit argument. And I think Fred teed it up well initially with respect to some of the issues that were raised, but there was also the issue of APA notice, which came up a bit as to paid prioritization, IP interconnection. Can we talk a little bit about that issue? And Brantley, I don't know if you've got some thoughts on the APA side of things.
Sure, that was a particularly interesting issue in the context of mobile broadband, because the issue was raised that one of the parties had, during the notice comment process, briefed some of the questions. And obviously the petitioners were arguing that there was not enough notice. There was only a couple sentences in the initial proposed rule that indicated that the FCC would consider that issue, and they argued that there was no notice that they were going to approach it in the way that they ultimately did, with redefining the public switch network and rejiggering the functional equivalence test. The FCC pointed out that CTIA had submitted a lengthy submission on sort of the questions that ultimately came up, and that presents an interesting question of if a party does really paper the agency with input about an issue that wasn't necessarily well noticed in a proposed rule, does that ultimately take the issue off the table? And I think the parties, I think the petitioners argued that, they, in addition to the fact that they couldn't anticipate all of the arguments, the fact that they had submitted some papers on the issue should not excuse the FCC from properly noticing issues. And we shouldn't have a sort of notice and comment process where parties, even sort of parties with a lot of resources, have to just fill the record with every sort of possible issue in order to anticipate any direction that the agency will take, and then that ultimately counts as proper notice.
I would just especially refer you to, in the discussion in the oral arguments, about 11 minutes in, if you listen to the oral argument recording, and you can stand the mic pops, which are quite bad. This exact issue was raised by the petitioner's counsel, who said that after the FCC was encouraged to change course by the president, the petitioners scrambled to try to get into the record responses on every issue they could conceivably imagine the FCC addressing, because they figured the FCC wasn't going to do what it really ought to have done, which is to issue a further notice of proposed rulemaking, explaining its proposal. And they still were not able to predict that the FCC would end up doing what it did, which was changing course at the last minute after Google insisted that reclassifying the entire service would end up regulating them. And therefore, the FCC decided it had to invent this new ubiquity standard and abandon the standard that it used to use for deciding whether something was sufficiently interconnected, which was essentially an antitrust standard. So if this sounds legalistic, this notice issue, it's really not. It speaks to the fundamental question of agency expertise and deference, which is the agency, the whole point of the APA is the agency is supposed to ask questions that are sufficiently clear that you know what it is the agency is proposing to do, and you can respond in a way that actually guides the agency. When the agency fails to do that, fails to put out a new notice when it changes its mind and changes course, it denies petitioners the ability to comment, or commenters the ability to provide feedback on what the agency is proposing to do and the pitfalls of doing that. And it also means the agency doesn't really doesn't deserve, in my opinion, the deference that is normally accorded when it makes decisions in accordance with the proper rulemaking process. And I think it's pretty likely that if the FCC does somehow get through the other statutory hoops, that it'll still lose on notice grounds, and this whole issue will go back to the FCC for yet another round.
I would like to correct the record. Berin just said that the comments by AT&T and CTIA on the Section 332 issues came in a rush after President Obama weighed in on the issue. Nothing could be further from the truth based on the record. The truth is this. CTIA offered comments on the functional equivalence standard in its opening comments. It offered comments on the question of updating the definition of interconnected service in its reply comments, which were September the 15th. There were weighty comments on the redefinition of interconnected service on October the 17th. President Obama did not weigh in until November the 10th. Going to the comments that I think Brantley made, I wanted to acknowledge the validity of some of what she said. I do think that the fact that there were weighty submissions by AT&T and CTIA is relevant in two respects. What I acknowledge is that you cannot do away with any agency notice and say, look, people talked about it and therefore there was sufficient notice. That you cannot do. But the fact that there were weighty comments is relevant evidence that supports the agency's contention that in fact there was notice. And it is relevant also in one more respect, and this did come up in oral argument, and that is whether there was any harm. There is one court case, Judge Silberman case, Alina, where Judge Silberman said, look, if we find that there was no notice, but the complaining parties offered pointed comments, then they're hoist on their own petard. And so those weighty comments do go to whether any error, as may have been committed, and this is also an open question, was harmful or not. And finally, to go back to what I said in my opening remarks, I think it may be a little premature and simplistic. While it is true that the court, in some of its questioning, directed skepticism towards the petitioners on the basic reclassification issues and towards the FCC and our side on some of the mobile issues, it would be premature to jump from that to a conclusion that there would be some Solomonic splitting of the baby. We have to wait and see.
Well, that raises the issue that one of the judges raised, which again ties into the mobile broadband piece, where he said, wow, if the standard is that, or if the standard varies from what room in the house I may be standing in, there might be Wi-Fi, which is a fixed service in one room, and then I move to a different room and I'm connected through my same tablet or iPhone to the cellular network. Is that really going to work? And that ties into your comment. So how do you think it would work if in fact there is a remand to the FCC with respect to mobile broadband, but fixed is upheld?
This is exactly what I meant when I said that the court will seek a viable solution to this. And Judge Srinivasan's questions could be read to reflect the view that when you subject yourself to a different regime, depending on how many steps you take away from your front porch, that solution might not necessarily be viable.
Yeah, hashtag Congress problems. I mean, the fact that you might get a screwy result because of the way the statute is written doesn't mean the FCC gets to rewrite the statute to do whatever it wants. It means, fundamentally, the Communications Act is broken. It doesn't make sense anymore. And it's not going to get fixed until the FCC stops pretending that it can solve these problems. Right? We could have a legislative fix that addresses that concern. So I just have to say, I find this really indicative of a larger tendency towards ends-directed thinking here. The means justify the ends. Who cares how we get there? Let's just do what we need to do to get the result we want. That's what's happened here for 10 years. That's what the FCC has been doing. And it has culminated in the president telling having this angry mob outside his gates, being all upset about this issue. His staffers deciding that after losing in the midterm elections, that they needed to find areas where the president could assert his authority and act unilaterally. And then deciding that this was the area that they were going to get involved in, and making a big speech to interfere with the decision-making of an independent agency, urging the FCC to invoke Title II of the wrong act. I mean, the fact that the White House doesn't even understand which Title II we're talking about, it's Title II of the 1934 Communications Act, not Title II of the 96 Telecommunications Act, really belies Markham's insistence that this is all driven by careful consideration, that everything's been thought through in very detailed ways. It hasn't. Nobody's really thinking through these issues. It's been badly lawyered by the FCC, badly researched. There's not a careful consideration of the costs and benefits, let alone the unintended consequences of the order. And each of those things creates reason for concern. It creates reasons why, if not at the DC Circuit level, then at the Supreme Court level, I do think you're going to see the court ideally say that Chevron doesn't apply, but it may find other reasons to stop the agency.
So would a remand open the door to Congress or some other result? Panel? What would open the door to Congress? Would it be a remand or something else?
I expect almost any result will open the door for Congress. I don't know whether they'll decide to go through that door, but you know, the issues are complex enough. Almost no matter how it comes out, it's probably going to be unsatisfactory in some way, at least from sort of a legal perspective. And I think that sort of answers kind of both what Michael and Berin were saying, is that, you know, when I clerked for a judge, you know, all judges, you know, have their own views and the like, but at least that court at that time, the view tended to be, it's not our job to fix problems in statutes. I don't know what the court's going to do here, but the Communications Act is convoluted at this point. I do think Judge Srinivasan noted I'm going to paraphrase, but this is pretty close. What we're doing here is applying a statute written for a telephone network to a broadband network. I mean, they recognize the difficulty of this. On some level, I think they all would probably at least espouse the view it's not our job to fix it. We need to apply it. We need to decide this case. But so that's too long, isn't it? But bottom line is, I think the door's already open for Congress, and I think whatever result you get here, it's still going to be open. And it's up to Congress when it decides if the time is right to update.
Combining what we heard from Berin and from Fred with what I read in the Con Daily article yesterday, it seems that a legislative resolution is one of the favorite friends that people look over the heads of others to find in that cocktail party that our oral argument has become. But the heads over which we would be looking to find that it's a resolution are the heads of 3 judges on the DC Circuit. So I think it's premature to speculate about that.
Let me ask if there were any surprises or sleeper issues that the court identified that anybody would like to comment on. Brantley, anything come to mind for you? That you
Issues that the judges did comment on?
Did comment on that were surprising or unusual, a surprise, even a sleeper that, wow, I wasn't expecting that to even come up and really came up quite a bit.
Well, I think to some extent Judge Williams sort of interlude on traditional common carrier regulation and how that fit in with the FCC's current ban on paid prioritization was interesting. He obviously has a wealth of knowledge about the issues, and he really challenged the FCC's lawyer on the actual factual basis underlying paid prioritization and said, look, traditionally common carrier regulation in the railroad industry, if you need to carry refrigerated items, you pay for a refrigerated car. Isn't that the same here? And has there been any showing that paid prioritization would ultimately harm overall internet traffic? Now, the analogy is obviously not perfect because all cars are tacked onto one train, and it's not going to slow up the non-refrigerated cars if you have refrigerated cars. But I think he was focused on, he was scrutinizing the record for a proper showing. And I think, as I said at the beginning, the judges are obviously aware that here the FCC has changed its course. It has imposed sort of, in Judge Williams's words, sort of more burdensome regulations, and it certainly has some notice problems. So I think it may be that those factors combine to a closer scrutiny of the record, which is obviously, fact-finding is traditionally a key area of deference to an agency. But I think here, Judge Williams did indicate sort of a close scrutiny of some of the actual facts in the record.
The only thing I would dispute with that is that a refrigerated car wouldn't necessarily slow up the other cars. I'm a railroad fan anyway. Fast freight often does slow down slower freight, and it's just part of the deal. I liked the analogy.
It's an astute point, and indeed, it's a sleeper issue in the sense that, remember, this was the reason fundamentally for using Title II, was the idea that using Title II alone would allow the FCC to ban paid prioritization. Remember that last in May, when Tom Wheeler last year was asked about this, he said to Congress, well, even under Title II, we recognized that we actually couldn't ban paid prioritization. I mean, in other words, the FCC, when it was thinking about the substance and the law, was realistic about this, and it understood that Title II is fundamentally about just and reasonable discrimination, which means you can regulate how prioritization is done, but you can't ban it altogether. Only after the president intervened did the FCC suddenly decide that, they could just use Title II to ban paid prioritization altogether. So I think Brantley's right. I think that the fact that you can't even do the one thing the FCC really feels it needs to do under Title II will really hurt the FCC in the analysis of the case. But I'd point out a second thing, which is, I expected the full service networks discussion towards the end to be kind of irrelevant, frankly. But I think it is important in one particular respect, which is their entire argument really is about the agency's discretion under Section 10 to grant forbearance. And I think that discussion, oral argument, really is going to expose the FCC to the UARG issue I mentioned earlier, because in response to full service network, the FCC had to come out and say, no, Your Honors, under Section 10, we have broad discretion to decide what we think is the right course. Well, you can't have it both ways. And once you start going down that road and you acknowledge that your discretion under Section 10 is quite broad, and that under Fox, the agency can always change its mind if it offers a reasoned explanation, what the FCC does for forbearance becomes purely short-term dispensation. It can be reversed later, as is made clear if you read the caveats in the Open Internet Order. And that in turn means that what the FCC is doing here to try to fix the problems with Title II is just that. It's a short-term dispensation that may change in the future. And that in turn raises the argument that I raised earlier about UARG.
Eve, thoughts for you?
Well, just going back to the paid prioritization issue for a second, I mean, Berin's right. So the FCC has a statutory provision that is specifically addressed towards discrimination. It's Section 202. And the FCC admits in the order that it could not accomplish the ban on paid prioritization, the complete ban that it adopted under 202. So it goes on to say instead, oh, well, we think that we can ban this as an unlawful practice under Section 201. And this is another, it didn't get attention at the oral argument, but I think when the judges look at the briefs and the record, Section 201 wasn't mentioned in the notice of proposed rulemaking with respect to paid prioritization. So you have another situation where they have a rule that doesn't match up with the statute, and they've kind of reverse engineered a rationale under the Communications Act to fit the rule into, you're fitting a square peg into a round hole again, and it just doesn't fit together quite right.
I'm about to turn to audience questions, so be thinking of your questions. And in the meantime, I'll ask Markham, any surprises or sleeper issues from you?
No, not so much. I mean, I thought that this was an incredibly, without sounding too self-serving, an incredibly well-argued brief case, and I'd say that for all the parties. This was a very robust docket. This was a very well-pleaded docket, and it was a very well-pleaded appeal. And I think, and this court is a court that has a tremendous amount of expertise over this issue, Judge Tatel in particular. And I think the oral argument reflected that it was a very well-briefed case. That tends to show that there weren't a lot of surprises. The issues were properly before the court. So I think the fact that there weren't a lot of surprises demonstrates that it was a well-argued case on all sides.
Before we turn to the audience, I just have to disagree. I don't think it was well argued in the sense that there are major questions that were not addressed. Last time, the case didn't address several major questions. The no blocking and non-discrimination rules would have survived if the FCC had bothered to ask the court to rebrief the case after Selco. In other words, major questions that totally changed the outcome of that entire case simply were not addressed. And I think the same thing is true here on the issues that I keep mentioning, and I have to take some responsibility for that. I mean, TechFreedom was an intervener. Quite frankly, we assumed that our issues would be addressed in oral argument and that the petitioner's counsel, because he had argued the UARG case before the court, was far better qualified to address that case than we were, and we decided not to insist on time in oral argument. What we didn't realize was that not getting time in oral argument might mean that all the other difficult issues in the case would end up eating up all the time, and that the things that the Supreme Court may end up focusing on simply did not get discussed. And so that omission, to me, I think was a little surprising.
Interesting. Let's turn to the audience. Question, yes, right up front.
Brian Fong from the Washington Post. I'm wondering if you guys can help me understand when this goes to the Supreme Court and the conditions that would have to be in place. I mean, just to take an example, if there's a... Sorry, to show you this again. Yeah, no problem. Brian Fong with Washington Post. Questions about when this goes to the Supreme Court and what conditions have to be in place for that to happen. Just to give an example, if there's a partial remand, then how does it wind up at the Supreme Court?
One of the characteristics of the Supreme Court is that it is the highest court in the land, and that is a consideration that will be on people's mind if they have to weigh whether to take it there. In other words, the allure of filing a cert petition may be offset by the fear of getting a negative decision from the Supreme Court if the court were to accept cert. So that's one tactical consideration that will apply. As for procedure, if there is a decision, and if, as you assumed, Brian, it's a partial remand, as you described it, both sides will have the option first of requesting en-banc rehearing from the DC Circuit before going to the Supreme Court. And I suspect that it would be an option that will attract some serious consideration. Again, not knowing, of course, what the court will rule. And I think that a cert petition might come after the case is either heard or rehearing denied. As for the chances of grant of a cert petition, it's just too early to tell whether it will fit within the very narrow subset of cases that the court accepts cert for.
Well, in case you haven't noticed from everything I've said today, I'm chomping at the bit to get this case before the Supreme Court, and we will, and we have standing to do so as intervenors, we will be filing a cert petition if we don't win on our issues. And I can probably assume that Alamo and Berninger are going to do the same thing, and I think that's probably true for all of the petitioners. Nobody on our side wants to tie this case down any further. We want resolution. We want resolution on fundamental doctrinal issues that are better resolved by the Supreme Court. But I think the same is probably true for the FCC, and I think it's in part for political considerations. I mean, let's just think through the timeline here. This is probably useful for those of you who want to think about what this case means for consumers and how it's going to play out. I would expect a decision to come down likely at the end of the DC Circuit's term, which is in June. Could be a little bit earlier, but it's going to be a hard decision to write. And they're probably going to run down the clock on it. And so that means that the window for cert is going to be coming up in the fall, and this entire case is going to be driven in part by the election. And if I'm the FCC and I lose, unless Donald Trump ends up looking like he's the Republican nominee and the Republicans look like they have no chance to win, I don't want to take my chances that a Republican might end up taking control. I want to start the proceeding at the Supreme Court, where at least I can file the briefs, the initial briefs. So in other words, I would want to make sure that I can get the case addressed as quickly as possible while this administration is still in control and while the current Obama Solicitor General can control at least the early stages.
Other questions? Yes.
In addition to the notice question, Judge Williams asked some very pointed questions about the adequacy of the Commission's response to specific economists' comments. And I wonder if the panel has thoughts about what the likely remedy would be, or if Judge Williams finds someone to share his concern about either the notice or the adequacy of the response.
Well, I probably should allow the people who do appellate legal work answer this, shouldn't I? I believe people, or there have been cases that can be reversed on grounds of not addressing all legitimate issues, but maybe I'll just stop there because you have others.
I mean, it boils down to a question of whether the court would vacate a rule for failure to either provide adequate notice or respond adequately to comments that were made. And there's a sort of balancing test that the DC Circuit applies. The petitioners here asked for vacator of the rules, the theory being basically that the Commission has tried this many times, and if the court finds in their favor, has been unable to do so. So if the court were to agree with that, they would say sort of it doesn't really matter whether they could go back and address this question. That's not really the issue. But oftentimes when you have, if that were the only problem and there was just a failure to provide adequate notice or the failure to address some comments in the record, you'd typically, I think, see a remand.
The problem here is that the nuanced approach that Judge Williams asked about below has now been abandoned by the petitioners. In other words, there were some people below who said, it needs to be nuanced. It needs to be a general standard, case-by-case adjudication, commercial reasonableness. Now, on brief, the petitioners are saying we don't want general standards. They're too general, they're too vague, they're in fact unconstitutionally vague. So that blunts the possibility that this will be a significant issue.
Yeah, Pantelis is pulling a bit of a fast one here, if I may say so. There's a fundamental difference between the commercially reasonable standard that the industry was asking for last year and what the FCC has ultimately done. It is true that they are both, they seem to be similar because they are both case by case. They both allow for ex post adjudication of issues. The fundamental difference is where the presumption lies and how much discretion the agency has. And to put it most simply, commercially reasonable standard is a presumption of legality, where the agency bears some burden to show what the problem is. What we have wound up with instead is essentially, call it a presumption of illegality if you want, think about it in terms of the FCC's discretion if you prefer. The point is, under this standard, the agency gets to decide what is lawful and what is not. And there is a line of Supreme Court cases that I mentioned, starting with the benzene case in the 80s, and most recently revived in Michigan versus EPA, where the court has said that when you have that kind of a standard and you fail to do careful cost-benefit analysis, and that would include, for example, not responding to former general counsel, chief economists of the agency, 3 of whom filed in opposition to what the FCC was doing without response from the FCC, that raises not merely questions about administrative procedure and whether the agency has met its burden there, but fundamental constitutional questions. And again, I think that's the kind of thing that the Supreme Court seems to be heading towards, and you may end up seeing causing the agency to lose altogether, not merely to be remanded for new fact-finding.
Thank you. Other questions?
Tom Struble, TechFreedom. I had a question about the wireless reclassification portion of the arguments. This may be Fred Pantelis best able to speak to this, but others can chime in. So in the order, the FCC reinterpreted the public switch network to include both the traditional North American numbering plan and the newer public IP addresses. I thought one thing that was interesting and was surprising to me in the arguments was the very semantic argument about connected with the public switch network versus interconnected with the public switch network. And whether or not it's enough that anyone with an IP address can reach anyone with an ANP number, but the reverse is not always true. If you just have a phone number, you can't necessarily reach anyone with an IP address, or even most. So I guess I'd be interested to hear what you two think about that, whether you think that argument holds water, or whether it's just out of left field.
Well, I think it's a step one Chevron question. I mean, if you look up connected in the dictionary, it has a broader meaning than interconnected. Why add the prefix inter if it doesn't mean something? Interconnected, according to most plain language dictionary definitions, and contains a mutuality requirement. Connected doesn't necessarily. Connected can mean related, but interconnected typically the mutuality requirement would require both sides to be able to communicate in this instance. And so the issue is sort of the plain language meaning of the statute. Does interconnected remove any ambiguity, if you will, about whether there has to be a mutuality of connectivity? You know, as I understand the argument on Pantelis' side is that, look, it's a good enough that it's a substantial number. That might be if you're at step 2. So, I think the connected, interconnected, I at least in my view, is probably a step 1 question that then you don't get to the substantial question, because if the court would conclude interconnected, it requires a mutuality. But I don't know what the court's going to do, but I think that's what they were arguing about, at least I believe. I don't know if you've got a different view.
Yes, I would only say that the question of substantiality would be in step 2, as you called it, Fred, if this was something that the FCC came up with. But substantial is used in the statute. So the statutory definition of commercial mobile service itself is a service that is interconnected with a public switch network, but that is made available either to the public or to such classes of users as to be effectively available to a substantial portion of the public. That's the provenance of substantial. And in turn, both interconnected service and public switch network are building blocks of that definition. So the argument we have made is that their meaning should be informed by what Congress wrote.
Something really important just happened here, and it's really critical to understanding how this case is going to be resolved. What they're really discussing is both how this particular question will be analyzed, but also under what standard. In other words, what step of Chevron. And Chevron generally is understood, so there's the question, is it ambiguous? And if it is ambiguous, step 2, is the agency's interpretation reasonable? Well, there's increasingly in the Supreme Court's jurisprudence, there is a step 0 being applied, which is, does Chevron apply at all? And that's what I keep emphasizing. I think what the Supreme Court did in King versus Burwell, although it, of course, upheld the administration's policy agenda, what it actually did was to say that for questions of major economic significance, we're going to analyze these questions under step 0. It's not entirely clear, it could still be step 1, but they seem to be moving the analysis up. In other words, Fred's points about the dictionary definition, those may not even be relevant if the court considers that the implications of what the agency is doing here are so significant as to raise the same kind of concern. And then just to respond to a point that Pantelis made earlier, he dismissed King versus Burwell, saying that the only issue there was that the IRS lacked expertise. I think it's pretty clear if you read King v. Burwell that that was simply icing on the cake, that the court was first and foremost emphasizing the importance of the question, the fact that the FCC, or the agency, excuse me, was regulating there about the same percentage of the U.S. economy as is potentially implicated by the FCC's regulations here, 1/6 or 1/7, roughly speaking. And the fact that the IRS lacked expertise was merely icing on the cake, and it was not actually the FCC, the reason that the Supreme Court did not apply normal Chevron deference.
Just that, I know we're at the question stage, but I also think something was illustrated by that conversation about, some of the complexity here, and these are complex legal issues and arguments, and I don't disagree with anything Mr. Pantelis said. It comes back to when my opening comment, though, about one of the justifications for reclassification is we'll be on a stronger legal footing, and I made the argument, perhaps obviously unsuccessfully, that you're going to raise a whole lot of new and complicated legal questions if you reclassify, and I think we're seeing the results of that. The court, had the FCC followed through with its original notion of adopting a 706 approach. None of these things are on the table. These questions of interconnected versus and the like, and so the FCC, I guess I'm saying it illustrates the FCC took a large risk here. The relevance of that going forward. I mean, it is what it is now. But if issues were to get remanded, it might mitigate towards perhaps a more conservative approach by the FCC for its 4th go around. If we get there, I don't know.
Great. Well, I think we're at time now. This has been a fabulous panel.
Do you want to do a quick wrap?
Sure. Yeah. If we have time. Okay. That sounds great.
Well, I'll just start by responding to what Fred said. A more conservative approach here would be 3 things. One, I don't think 706 is a grant of authority, and yet I would still prefer the FCC use that. But it has another tool, which is the ancillary jurisdiction. I mean, that's what the FCC could have used after it lost in 2010. It could have done a better job of tying regulation to specific grants of authority in the Act and making the case for them. And that, at a bare minimum, could certainly be used to uphold a transparency mandate and enforcing that, and I think that alone would be more than adequate to deal with the problems here. But fundamentally, the agency could just go to Congress and ask for authority. I've already said I think this case is going to be really the definitive case for understanding how Chevron, when it applies and when it doesn't apply. And that is what this case will be remembered for when the Supreme Court decides it, not net neutrality and not the particular details of the Act.
I agree with what Berin just said, and I think that we since Friday, and even going into the arguments, we all knew that this was going to be a hard-fought battle. Lots of difficult questions came up at the argument. I agree with Berin that a transparency rule standing alone could solve a lot of the FCC's problems. The FCC went out of its way in the order actually to note the benefits of a transparency approach, whether or not the agency actually would agree. After a remand, that it was enough standing alone is anyone's guess, but I do think that if they lose this time, some careful thought on what type of more conservative approach would pass legal muster if we continue to want to regulate the internet would be definitely in order, so we don't have to keep coming back to the court to fight it out.
I think it is impossible to predict what the court will do, and you heard it here first. It's not even a prediction because in all likelihood a decision may have already been reached, and I think we should all give ourselves the luxury of some suspense.
I think I've said enough today already.
Okay, I guess I'll say a little bit more. I think one of the most interesting issues in the case is that a lot of the parties sort of at least somewhat agree on sort of a common goal of a sort of free internet. And I was very interested by the judge's sort of willingness to really look at sort of the best means to achieve that goal and sort of step beyond the traditional sort of deference frameworks and analyze sort of some of the policy concerns at issue in the case. And one area where I saw this really played out was the discussion of the FCC's sort of case-by-case approach here. And it's already been said, that in the First Amendment context, there were some concerns expressed about the FCC deciding, who is a speaker and when they are speaking. Similarly, just under the Title II framework of the FCC making decisions about whether a broadband provider's sort of new technology initiative or new business model is appropriate under Title II. This also sort of, raises concerns about the FCC's sort of general authority and capability of, overseeing the evolution of a technology like the internet and making decisions about how that technology should actually progress. So I think, it will be interesting to see whether the judges actually get into some of the sort of on-the-ground facts and policy issues that are so clearly at stake in this debate.
Well, first, Berin, thanks for setting this up, and thank you all for being here. Appreciate that. I will agree wholeheartedly with Pantelis. I will not hazard a guess on the outcome of the case. I'll make 2 points. One is that I would underscore that what's happening here before the D.C. Circuit and at the FCC is not so unusual in the fact that the regulated not infrequently challenge the regulator and say that the regulator's regulations go too far or burdensome. This isn't that extraordinary of the case in that regard. Secondly, the fact that 4 million people submitted comments to the FCC, I think, underscores another part of this. That the internet is a very personal platform for people. Whether you're on Berin's side of the equation or you're on our client's side of the equation, frequently the strong held views are because of the importance people feel the internet is in their lives. And if you question that, try to take away a smartphone from a teenager. So whenever people think that the internet's being threatened, they feel and react very strongly. So I think going forward, I don't see that diminishing, and so I think even as this evolution of the open internet arc continues, I don't see those passions diminishing as the internet will not be less important in anyone's lives. And so I think even as we see further iterations of rulemakings or adjudications, I don't expect the passion to subside.
Well, thank you to TechFreedom. Thanks to the audience. And in particular, thank you for these great comments from the panelists. Terrific. Well done. Thank you.